1, 2. Hello, hello. This is Just Human, episode 349. And we have we have a lot of information to catch up on the United States v. Comey docket. There have been some significant filings, both in their breadth and their weight and in their how consequential they may be. The filings that have hit the docket in the past 24 hours, I think, likely kill the case and kill the case for the right reasons. That's not based on my opinion of Comey and whether or not I think he's guilty of one or other things. That's based on these filings and the information we have about the case and the evidence in it and the allegations not matching up with the actual indictment. The actual indictment doesn't match the discovery that has been presented and that the motions are now based on. We have a conflict here between the indictment and between the evidence being used. And I think it's a fatal flaw to the case. We also have some other developments on the docket that have to do with attorneys and filter team and all those things. And I want to take you through those. Today on the show, we have so much to go through. I think I want to try and do a favor to the two types of audience members I believe I have. I have audience members who come here for the key information that I go out and find through all these cases and documents and in the news. And they kind of want that stuff delivered pretty early on in the episode and without going page by page through the documents. And then I have another portion of my audience who loves going page by page through these documents and digging and finding things out together and pondering possibilities, just continuously thinking about these things and chewing on them. And that's more so my style and how I go about this, but I want to try and honor both types of audience members. So what I'm going to aim to do, considering how many pages we have to go through today and how much has happened, what I want to try and do is in the first 30 minutes or less of this show, I want to give you a brief overview of the Comey news. It's going to be a Comey-focused episode. So I'm going to try and give you a brief overview of all the latest developments on the Comey case. And then after I've done that, go back into the documents and do the digging. And if this works well, this may be a new format for the show, at least when we have a show that's this loaded up based on basically one topic or one subject matter, and then we'll go through all the subsections of it later on. All right. If that sounds good to you guys, well then welcome. You're in the right place. My link tree is in the description of the show. It's also in my profile, wherever you're watching or listening to this. And on my link tree, you can find all the places to follow me, all the places to watch, all the places to listen, and all the ways to support. Thank you to everybody who's bought me coffee recently. There have been a few of you who went out and refilled my coffee cup. There's also been a few of you who have subscribed to my Substack, justhuman.substack.com. That is the best way to support this show. Both of those ways are awesome. And I appreciate everybody who's gone to Benson Honey Farms, Bootleg Products, and Manly Cans and used my affiliate link to make purchases for yourself or for a friend there. Every time you make a purchase there using my affiliate link, they kick a few dollars my way, and that goes to support the show. So thank you guys very much. Like I said, Substack is the best way to support the show. A paid subscription there, $7 a month. And, you're buying me a cup of coffee and you're contributing to my Pacer fund to buy documents off of Pacer. And I really appreciate that. That's what makes the show possible. I did have issues with Substack, or rather Substack itself had issues in the past 24 hours. I think it was related to the AWS, Amazon Web Services outage, which affected, 100 different websites. Substack was really struggling yesterday. So Substack ended up being the last place that my most recent episode dropped. That episode is about Smartmatic being indicted or added as a defendant in an ongoing case, and some other news items. Also, Landmark Antifa case, which I'm going to be covering. So I apologize to my Substack audience that they were the last to get this episode. Usually the Substack audience is the first. And if you want my episodes as soon as possible, you need to either subscribe to justhuman.substack.com. You can get it. You can do free. That's fine. It's just a paid support. It's the best way to support the show. But if you are a subscriber there, then you'll get an email notification or an app notification that the episode is ready. Rumble was the most stable place and uploaded for a change and uploaded my episode no problem. Rumble is where I have my playlist for all of the different cases I've covered and different reports, including United States v. Comey, and a podcast or a list of just my podcasts and all of my clips. And soon I promise I will be doing playlist over here on YouTube. Thank you to everybody who subscribed to me on YouTube. I'm trying to build up my YouTube audience, having just got this back. And so thank you guys for liking and commenting over here. That really helps me grow in the YouTube algorithm. It's like a lottery over there. And the more you interact with my page and my videos, the more basically lottery tickets I have on YouTube to get into the algorithm and get featured on people's pages and recommended in the algorithm and all those things. And X is where I do my threads. And I've done a lot of threads lately. And those threads are going to be what I use to go through the updates on the Comey docket. So we need to go back to catch up. We need to go back to around document entry 48 or so. Yeah, October 17th, Comey asked permission to file excess pages. There's a rule about how many pages a filing has to be. And so he asked the judge this is totally normal, to file excess pages, and the judge approved it and said, yeah, and the defense can also file excess pages in response. And then shortly after, a bunch of attorneys appeared. And that's our first update. There have been new attorneys added to Comey's team. And these are very notable additions. Comey already had Jessica Carmichael as the local attorney, I believe she is, who has a bar license here in Virginia and is familiar with Virginia rules and all of those things. And then he has his lead counsel, who is former special counsel, former attorney general, very legendary DOJ person, Patrick Fitzgerald, who prosecuted key terrorists, prosecuted various corrupt people in government, and just a legend. An old man now, but a legend. And he's also a longtime Comey friend. They work together a lot, and he has been Comey's attorney, personal attorney, on a number of matters for over a decade. But added to the team now are some big names. Michael Dreeben is probably the biggest. Michael Dreeben is former Deputy Solicitor General, a longtime DOJ prosecutor, and he was a member of both the Mueller and Smith special counsel teams. So he is someone that a lot of people on the right absolutely hate and say is a swamp creature. He's deep state as much as anybody can be deep state and all of those things. I don't know if that's true. I don't honestly know if that's true. Maybe he is. Or maybe that's just a characterization in the narrative. So much these days is just narrative. But I'm going to go by what I see in this case. And this guy is a heavy hitter and a big hire onto Comey's team. Next person is Elias Kim, a younger person, but he was a litigator recently for the Department of Commerce and the Solicitor General's office. He's experienced in appellate issues. So that's probably why he's added to the team, is because there's an expectation, whatever happens, it's going to be appealed. There's probably going to be decisions that are made over motions that are going to go up to an appellate court, like ones having to do with Halligan's appointment or the privilege issues, which we'll get to in a minute. So I think that's why he's there. Next person, I'm going to say his name Ephraim. I'm not sure exactly, McDowell. He's another alum of the Solicitor General's office. Recently was there and also worked in the White House counsel's office. And then Rebecca Donaleski. That's another big, I would say, heavy hitter. over a decade of experience as a prosecutor for the SDNY. She led the public corruption unit there, and she was involved in the prosecutions of Senator Menendez, Ghislaine Maxwell, and Michael Avenatti. So Comey just added some big power to his team, some significant people with significant knowledge and experience on both the prosecutions, or mostly on the prosecution side, but then also on the appellate side. And the Solicitor General's office is going to be experience at appellate level and at the Supreme Court, right? Big enhancements to his team. We knew that we knew it was coming, that there was going to be motions to dismiss on Monday, and there will be. And Comey notified the court that, hey, I'm going to be filing a notice to dismiss, a motion to dismiss based on the unlawful appointment of Lindsay Halligan, which is going to have to be heard out of district by a different judge. This is the way things work. It's going to be a third party or someone a little bit more disconnected from the district. I'm not sure where it's going to be. Next significant development on the Comey docket is DOJ having earlier filed for a filter team. We went over that on a previous episode, I believe, right? We went over the filter team filing, didn't we? I'm trying to remember. Did we? Yes, we did on episode 346, which was 6 days ago. We went over the filing for a filter team because there's quarantined evidence, and the quarantined evidence is evidence that was gathered from a different investigation. It would be Arctic Haze, the media leak investigations that we learned about over the summer and that were declassified, thankfully, or at least a good chunk of them were declassified. And that motion for a filter team is because, and over the course of gathering this evidence, which comes from Daniel Richmond, most likely, if not, it's David Kelly. And that information has to do with communications between Comey and Richmond, and Richmond was Comey's attorney. So was David Kelly. So was Patrick Fitzgerald. And so it would be attorney-client privileged information. And so Comey has the right to assert privilege over this evidence, over these communications, and say, no, you can't use those in this case. The prosecution can't even look at those because those are my privileged communications with my attorney. Therefore, it's protected. And so the filter team, this motion right here, number 38, right here, October 13th is when it was filed, has to do with that potentially privileged material. And it's been quarantined, which means it's been separated from other evidence and is not available to the prosecution. And a filter team would be made up of investigators from a separate division who don't work with the prosecutors. And they would look at that material and examine it for potentially privileged items and then show that stuff to Comey and give him the opportunity to assert privilege over it, which, of course, he would because we know the nature of it. And then it could be argued before the judge. And if the prosecution wanted to get it, the judge could then look at it ex parte and then decide whether or not it actually qualified as privileged or not. We went through this in the Sussman case with Durham, and Durham ended up getting access to a ton of emails that were some 1,500 emails, 1,300, I think, that were that Sussman had asserted privilege over, and said they were attorney-client or they were attorney work product privileged. And the judge was like, nah. And you may remember that the big line out of that was one of Durham's prosecutors told the judge, yeah, we don't need this stuff for this trial. Maybe the next one. Paraphrasing. Similar situation here. Well, DOJ, or the prosecution, I should say, filed a motion on Sunday night. It didn't hit the docket until Monday morning, asking Judge Nachmanoff to quickly rule on their motion to use a filter team to go through the evidence acquired from a separate investigation. That'd be Arctic Haze. That evidence comes from an attorney as a potentially privileged and could lead, they say, could lead to the disqualification of Comey's lead defense counsel, Patrick Fitzgerald. And you may have seen some headlines and some posts going around talking about how, Comey may lose his defense counsel. Comey has corruptly hired Patrick Fitzgerald, etc. But the thing is, the allegations in this case are about a supposed lie that Comey told to Congress that didn't have anything to do with Patrick Fitzgerald or any communications he had with Patrick Fitzgerald. So how could it lead to a conflict with him? And this is where the mishmash, this is where the confusion starts to creep in this case, where there's some, I don't know, you could say there's dissonance between what is the text of the indictment and the evidence and the filings that the prosecution is making here. And that dissonance is going to have to be resolved. Anyway, they urged Judge Nachmanoff to quickly rule on this so they can get this filter review started, because there's all these deadlines and the judge is trying to hurry this case through and get it ready for trial first week of January. And so he's got these due dates coming up and like, you got to do this and this and this and this. And DOJ wants access to this evidence, and they want to get any potentially privileged communication sorted and argue with the judge. They know that Comey's going to assert privilege. They know they're going to have to argue with the judge to give them access to it and pierce that privilege. And they want to get that process started. And they also want to see if they can disqualify Comey's lead counsel. So they filed this urging him to hurry up. And some of they say right here, we know because of the attorney we got this information from, that the current lead defense counsel appears to be a party in some of the communications. But here, I'll save the minutiae. I'll save the details of that for when I go over document by document. Well, Judge Nachmanoff came back hours later and denied the prosecution's motion and said, look, I'm not going to expedite my ruling on this because, one, the defendants haven't even responded yet, so I haven't heard from the other side. I got to hear from the other side before I say yay or nay. And two, as per local court rules, defendants have 14 days to respond, and it's only been 7. So, all right, stop elbowing me. Hurry up and make a decision on this. I have to hear from the other party. And then I can make an informed decision. It would be outrageous if the judge went ahead and approved DOJ's motion here for a filter team without ever hearing from Comey's side. Judge Nachmanoff also had more things to say, which I'll get into later in the show. Then we got the big filings. And by the way, I think Comey's side did respond to the motion to expedite. Right. That's the order. Let me see. There it is. Comey did file a response, or his counsel did, to the defense's urging, and they noted that, yeah, we have until October 27th to respond to this. And in that, they had a redacted portion in their response. And I'm going to go through this in detail later. But what was kind of interesting, this redacted portion, which Comey's team redacted on their own out of what they say is an abundance of caution because of the protective order in the case, and they didn't want to violate it. When the judge gave his order, he went ahead and said what was underneath these redactions, which is kind of interesting. And we'll go over that later. That's the kind of fun stuff that I like finding in the details of the documents. That's why I go by them page by page. Then we got the big filings. All right, so here's the big news in the case. a motion to dismiss for vindictive and selective prosecution, and a motion to dismiss based on unlawful appointment of Halligan. Now, in every case, defendants have a right to file to dismiss the case, and every defendant, put yourself in on the side of a defense table. You're going to want your attorney to file motions to dismiss based on every possible angle, right? Think back to Trump's cases against when he was on the defense side against Jack Smith, which we went through page by page, and I'm really glad we did, because that information is going to be super useful in looking at this case, guys. So all of you who stuck with me through Jack Smith's prosecutions and read those documents with me and digested them, and we tried to read and understand Jack Smith's point of view and what he was arguing, and then we'd understand and try and chew on what Trump was putting forth and his team was saying. And we read some stuff that was like super interesting, like, man, how are they going to get around that? And then we read some stuff was like, okay, that was just entertaining, right? And then we read some stuff was like, I don't think that's going to work. And then we read some other stuff that was like, that makes a lot of sense. What is Trump going to say now? Or what is Jack Smith going to say now, right? And we learned a lot from that process, and we're going to put so much of that to use here in understanding this. And one of the things we can look back on is that Trump also filed a motion to dismiss for vindictive and selective prosecution. And Trump also filed to dismiss based on unlawful appointment. And he also filed to dismiss based on a number of other things, spoliation of evidence and immunity and so many other things. I mean, I know there were at least 6 motions to dismiss, but I think there were more that Trump filed just in the documents case. And then he filed basically all of those same ones, except for the PRA, motion to dismiss based on the PRA. He filed like 6 motions to dismiss in the other one in DC on the election interference. Right? So defendants filing motions to dismiss, that's their right to do that. And they have the opportunity to do that early on in the case, as soon as they have discovery and they go through it. And in a case like this one, which seems straightforward, we're getting this 3 or 4 weeks after the indictment. And I predicted that these motions, specifically the one for vindictive and selective prosecution, I predicted to you guys that it would be quite hefty and possibly compelling. But I also said such motions, will it work? I don't know. Such motions rarely do. Rarely does it work that you say this is a vindictive prosecution of me. The prosecution has it out for me. The police chief hates me. The local attorney DA, he has a hate on for me. He's just coming after me. Defendants say that kind of stuff all the time. And Trump said that a lot about Mueller, who wasn't after him at all, and about Jack Smith, who was and did indict him. And he also said it about Alvin Bragg, and he said it about Letitia James, and he said it about Fannie Willis, right? These motions are common, but rarely do they work. It takes a lot of evidence to convince a judge that, hey, this whole thing was put together because so-and-so hates me. Either their boss hates me or the actual prosecutor hates me. So they went out looking and found a case and hodgepodged it together. They bastardized all this evidence and allegations together, and they brought this case against me. And it's super mean and unfair and unjust, and it's unlawful, and it should be dismissed on that basis. But this one from Comey, we knew it would be hefty, and I predicted it may be more compelling than most motions to dismiss of this type. And the reason for that is that Trump and Cash and Bondi have spoken out, especially Trump, have spoken out against Comey for years. And Trump has made post after post after post on social media and rally speeches. And Cash has written books and done podcast interviews. And so has Bongino, all talking about what a no good, very bad person James Comey is. And Trump has made promises to pursue and to go after the deep state, and Cash made an enemies list and all of these things. And then here they are indicting Comey. So it becomes that much easier to make the argument that, hey, the president, the attorney general, the FBI director, they have it out for me. And they hired a prosecutor to go after me. And the first prosecutor that was in the office, that Lindsay Halligan is now in, refused to go after me because he said there wasn't enough evidence to charge me with a crime. And when he refused, Comey fired him, or Trump fired him, and then put in this current prosecutor whose first move was to indict me because her boss told her to. And you have all of these social media posts to back that up. So it becomes that much more just weighty and understandable that, yeah, this kind of seems like a vindictive and selective prosecution here, based on the president's own words, based on the FBI director's own words, based on the AG's own words, based on the president and the AG's appointment of the prosecutor who only took that office days before she got the indictment against me. And the president made a post on Truth Social saying he was appointing her to do this. And all of those things are now in this 51-page motion to dismiss for vindictive and selective prosecution, plus 80 pages of exhibits. And do you know what 60 pages of those are? 60 pages of those exhibits. I believe it's attachment number 2. No. Here, hold on. Let me open it up. The actual motion is 51 pages long. Exhibit A is the appointment, the sheet appointing Lindsay Halligan. It became effective on September 22nd. Comey was indicted on September 25th, 3 days later. Exhibit B is the testimony that it's based on, which conflicts with the evidence. Exhibit C is, I think it's McCabe's interview, or maybe it's Comey's interview. I'll look at it here in a minute when we go document by document. Here it is. 60 pages of the 80 pages of exhibits in Comey's motion to dismiss the indictment for vindictive and selective prosecution are nothing but Trump's social media post about Comey, going all the way back to May 2nd, 2017. So look at this. "60 pages. All the way back from May 2017 to the most recent one, September 27th, 2025. 2 days after he's been indicted. Trump still going off on social media about how bad James Comey is. And how the FBI needs to go after him and the DOJ needs to go after him. And he's a crooked cop. He's a dirty cop. James Comey is on the day after, James Comey is a dirty cop. Make America great again. I thank Kash Patel for going after James Dirty Cop Comey. He's a slime ball. Great job, Lindsay Halligan. And just on and on and on. On and on and on. Now, maybe you agree with all these things. Maybe Trump is right. Perhaps you find it completely understandable that Trump would have these opinions of James Comey. And I think we can all agree that Trump has the absolute First Amendment right to post what he thinks of James Comey on Truth Social, on X, to say it in rally speeches, to put it into books, to say it in interviews. So does Kash Patel, so does Bondi, so do I, so do you. We all have the First Amendment right to tell whoever will listen or read what we think about James Comey. But when you're the president and you have the power to hire people in the executive branch, and you have the power to direct the authorities that the executive branch possesses, and those authorities have the power to actually do something about James Comey, such as bring charges against him, it becomes a bit of a different thing. And I'm not saying you can't do what Trump is doing here, but it does feed into a narrative that this case wasn't brought for the sake of accountability. It was brought for the sake of vindictiveness, and that it is a selective prosecution. And that's what Comey argues here. Just like with Jack Smith, if you remember, Trump filed I read the whole thing and was entertained by it. We read it together. I want to say it was about 30 pages. I want to say 27, actually. And it was Trump's motion to dismiss Jack Smith's indictment against him for selective and vindictive prosecution. And it went through and found all the times that Joe Biden said something about going after Trump, that other people said something about going after Trump, like Garland. And it was a lot of narrative, and it was very entertaining to read. It sounded like, I remember commenting, it sounds like Trump wrote this himself. But I also remember it had some things in it, I think, about the relationship between the White House and DOJ and NARA, the National Archives, and them looking for a crime with the documents, and then them selecting this document crime, even though the president has the right to has personal records and all of these things. Remember this? And even though it was an entertaining read and you could understand why Trump would say it, it also came across as Trump in a campaign speech talking about how Biden was after him and using lawfare against him. And it wasn't all that compelling. But something it didn't have 60 pages of Biden and people working for Biden talking about going after Trump. It didn't have anything like this. Not that I recall. I don't recall it having anything like this. And it also didn't have a deleted post from Biden, which this one does have, which I think is, pardon me for hitting the mic. Let me see if I find it real quick. It's not good. Deleted. Here we go. I'm going to go right here. James Comey. In turn, Trump responded. This is Trump responding to was it an interview or a Washington Post op-ed that was talking about Trump-style justice and A president who will reflect the core values of our honesty and decency that are the lifeblood of our nation and its institutions. That's the kind of president we need. James Comey, and in the Washington Post, an article from August 25th, 2020, titled, "If Trump-Style Justice Becomes the Norm, Nobody is Safe." Then it has a perma link here, which, by the way, I really love this. One of the things that I really like about these filings from Comey's team is they have a perma.cc link for everything that you can click on in the document, and it opens up right here, and boom, you have the link. No selecting and copy pasta, no Google Drive, no Dropbox, nothing like the House dopes have done with Epstein Maxwell material that they keep on grabbing. And anyway, that's another subject. Right. In turn, President Trump responded by retweeting attacks, calling Mr. Comey a corrupt piece of garbage, filth, a disgraced liar, and a sick and a leaker, and a weasel who should be in jail. By the way, all of that goes way farther than President Biden ever said about Trump that I recall. And let's go ahead and let's say that Biden said something just like that one time. Trump said it over and over and over again across years, including as recently as last month, while his DOJ was looking into prosecuting Trump. I'm not saying he can't say it. I'm saying that it feeds a motion like this. That's what I'm saying, guys. Don't get me twisted. I'm not saying that Trump can't say those things. I'm saying that it feeds into and makes more compelling a motion like this. Then we have a Donald J. Trump on April 30, 2020, and then deleted repost from Dan Bongino, who's the deputy FBI director right here. The only person on the planet who thinks Comey is a decent human being is Comey. We now know what a corrupt piece of garbage he is. What he did to Flynn was absolutely grotesque. He's filth, said Dan Bongino. Not saying Dan can't say those things. He can. Then we're going to get it in that other one. Then when you look at this next motion for unlawful appointment of Halligan, you have this deleted Trump post on Truth Social. I think I had it. There it is. September 20th. This is right before Lindsay Halligan was appointed. September 20th, Trump posted and then later withdrew a statement on social media directly urging the Attorney General, Pam Bondi, to prosecute Comey and to prosecute Attorney General James and Senator Adam Schiff, and to appoint Lindsay Halligan as interim U.S. Attorney. This was the post. It read, "Pam, I have reviewed over 30 statements and posts saying that essentially same old story as last time, all talk, no action, nothing is being done. What about Comey, Adam, Shifty Schiff, and Letitia? They're all guilty as hell, but nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past, a woke rhino who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him, and there is a great case, and many lawyers and legal pundits say so. Lindsay Halligan is a really good lawyer and likes you a lot. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice and indicted me 5 times. Over nothing. Justice must be served now. Signed, President DJT." Less than 48 hours after President Trump's post, Ms. Halligan was sworn in as interim U.S. Attorney for the Eastern District of Virginia. She was a special assistant to the president and a White House official. She had previously worked as an insurance lawyer and personal lawyer for President Trump and lacked prosecutorial experience. The Attorney General purported to appoint Ms. Halligan as interim U.S. Attorney under USC 546. On her fourth day in office, Ms. Halligan sought a grand jury indictment of Mr. Comey just days before the 5-year statute of limitation on these purported offenses was set to expire. No other prosecutor from the U.S. Attorney's Office for the Eastern District of Virginia participated in the grand jury. Ms. Halligan presented a grand jury with a 3-count indictment. The grand jury returned a true no bill, meaning no indictment. Yet after staying well past normal hours, the grand jury returned a true bill, meaning an indictment, on the other 2 counts by a slim majority. Only Ms. Halligan signed the indictment. And maybe you remember this post by Trump. Now again, Trump has the First Amendment right to post what he wants to. Just because he's president doesn't mean that's right, that he doesn't have that right. And he has the authority, he has the power to nominate people to serve in a post, and the AG has the power to nominate people and appoint people to serve in these offices. But that brings us to our next one. I hope I've made it clear why this motion to dismiss the indictment based on selective and vindictive prosecution is compelling. Now, the prosecution gets a chance to respond to this, of course, and we'll give their response a fair reading here and fair treatment. We'll treat it just the same as we did this, just like we did with other cases we've covered, right? You'll know that it's very rare that I come across a filing and I just like mock it, or I snidely go through it, or that I'm dismissive of it. We try and read it and see what they're saying. I think I let that kind of slide a bit on the Sean Combs case and on Bob Goldbar Menendez, where it was difficult at times to really see the defense's side. But on this stuff, I'm trying to be as fair as possible. I was with Trump stuff too, to both sides. I'm going to be the same here, or I'm going to do my best to be the same here. So there's your brief on the motion to dismiss for vindictive selective prosecution, okay? But on this one, for unlawful appointment, it's just as I had thought it would be. It's compelling because there was already an interim appointed U.S. attorney. That was Siebert. The way it's supposed to work, and this is by statute, and this is by the appointments clause, the president and the AG nominate someone to serve as the U.S. attorney for an office. That person then has to be confirmed by the Senate. This way, both the legislature and the executive are a check on the U.S. attorney's office, because the U.S. attorney's offices are one of, if not the most powerful office that's out there, save for the president, because they have the power to indict people, investigate them, and they have so much power. U.S. attorneys have so much power with their office. And we know this because we saw those offices being used against Trump. And we saw what a special counsel can do, right? We know how powerful these U.S. attorneys are. So there needs to be a check. And that check is that there's an appointment by the president and that the Senate has to approve. And there's also a custom of the blue slips, where the 2 senators from the state recommend some people to be appointed to the office. They recommend them to the president. The president doesn't have to go by that. But you typically see that happen, right? Trump, the U.S. attorney who was in the Eastern District of Virginia, resigned when, like, early on this year. I don't remember the exact date. It may have been January 20th, but it was early on this year. And Trump nominated someone to be there, and he nominated Siebert, and Siebert was the interim U.S. attorney. Here we go. Let me scroll up here to where it says exactly what happened. All right. Eastern District of Virginia. On January 20th, 2025, Jessica Aber, who was appointed by President Biden and was confirmed by the Senate, resigned as U.S. Attorney. On the following day, Attorney General appointed Eric Siebert as the interim U.S. Attorney. Mr. Siebert's appointment expired 120 days after the Attorney General appointed him, and that's per statute. That's per 28 U.S.C. 546. So that means his appointment expired on May 21st. At that time, the district judges of the Eastern District of Virginia exercised their appointment authority under Section 546 to unanimously retain Mr. Siebert as the interim U.S. Attorney. So this is how it's supposed to work. Someone gets nominated, they get to be the interim U.S. Attorney, but there's a 120-day limit on it. However, at the end of the 120-day limit, if the judges in that district approve so, they can then appoint to retain, or they can vote to retain that interim U.S. Attorney until someone is Senate confirmed. Or that person, they can vote not to, and then the next person in line, like the most senior person in the U.S. Attorney's office, who's next in line to be the top dog, is then moved up. That way there's someone from the office who's familiar and experienced in the office running the office until there is a nomination that is confirmed, okay? The Trump administration began pressuring, reportedly, Mr. Siebert to indict Mr. Comey and New York Attorney General Letitia James. When Mr. Siebert appeared unwilling to do so, Trump told reporters in the Oval Office that he wanted Siebert, quote unquote, out. Mr. Siebert resigned on September 19th, 2025. And we know that's what happened. Trump says he fired him, but this guy says he quit. He resigned, which is reminding me a lot of how Barr resigned and told the president when he was leaving office. And then later Trump said he fired Barr, which never happened. Anyway, it's a telltale sign of kayfabe, but that's another subject. On September 20th, President Trump publicly posted and later withdrew a statement on social media directly urging the Attorney General to prosecute Comey. We just read that statement. Less than 48 hours later, Lindsay Halligan was appointed. Now, here's the problem. There's already been an interim appointment. The president doesn't get to keep appointing interim U.S. attorneys. The Appointments Clause says that Congress has the Appointments Clause gives this power to the president and the Attorney General to appoint. The Congress in 28 U.S.C. 546 set the terms for these appointments. And what Congress had put in legislation, they limited the Attorney General's appointment authority to just 120 days. And the reason they did that is so that presidents and AGs can't indefinitely appoint interim attorneys who are not Senate confirmed, because whoever serves as the U.S. attorney is supposed to be confirmed by the Senate, but we can't have headless offices. So there's the ability to appoint an interim appointment, an interim U.S. attorney until someone is confirmed. Or failing those two things, the district judges can vote to retain an appointment until someone's confirmed. Or the next person in the office in line can then step up and serve as the interim until someone is confirmed. The whole goal is arranged so that there is someone appointed and confirmed by the Senate. And the reason we have this system set up is so that the office is never without leadership, so that it continues to function. But Lindsay Halligan is the second person to be appointed there as an interim, and it can't work that way. It doesn't work that way. According to just a plain reading of the statutes at issue, just a plain reading of the Constitution, Article 2, it doesn't work that way. And do you know who agrees it doesn't work that way? Who has already opined on it? None other than Samuel Alito. Now, it was all the way back in 1986 that Samuel Alito said this, and he said it when he was serving as Deputy Assistant Attorney General. But I doubt that Samuel Alito has changed his mind here, because it's based on a plain reading of the appointment clause and of 28 U.S.C. 546. The Office of Legal Counsel concluded back then, in examining the same issue, that while a vacancy exists when a 128-day period expires under the amended section of 546 and the president has either not made an appointment or the appointment has not been confirmed by the Senate, it does not follow that the Attorney General can make another appointment pursuant to 28 U.S.C. 546 after the 128-day period, which we are past when it comes to this office. The statutory plan discloses a congressional purpose that after the expiration of the 100-day period, further interim appointments are to be made by the court rather than the Attorney General. That contemporaneous executive branch interpretation provides persuasive evidence of the statutory meaning. In 2006, Congress entirely removed the 128-day limit and the district court's backstop role and simply provided that a person appointed to a United States attorney under this section may serve until the qualification of a U.S. attorney for such a district appointed by the president under Section 541 of this title. That amendment created a possible loophole that could permit U.S. attorneys appointed on an interim basis to serve indefinitely without Senate confirmation. And the executive branch swiftly capitalized on that. By December 2006, the Attorney General began firing Senate-confirmed United States attorneys. You remember this was a scandal at the time in 2006. And unilaterally replacing them with non-confirmed interim appointees who could serve indefinitely. The switch to an unlimited appointment was short-lived. In June 2007, Congress enacted a law restoring the pre-2006 setup. Do you guys remember this? It was called a massacre, wasn't it? If I remember right, the media was calling it a massacre when Bush fired all these attorneys and appointed all these interim attorneys to serve, and Congress was like, whoa. And then they went back. They were like, no. That's not going to work. And yet the Trump admin, when it comes to the appointment of Alina Habba and it comes to the appointment of Lindsey Halligan, is acting like it's 2006. So Comey's team has filed trying to wrap this up. This gets into the law and the statutes, and it gets complicated, but hope I've explained it well enough. You only get one 128-day appointment, okay? The president gets one and the AG together. They get one 128-day appointment to a U.S. attorney's office. After that 120 days, if there is not a Senate-confirmed U.S. attorney for that office, the district judges in that district can vote to retain that interim attorney until there is a Senate-confirmed appointed attorney, or the next person in line in that office gets promoted to lead the office until there's an appointment, a confirmed appointment by the Senate. The whole problem here is that we don't have a Senate-confirmed U.S. attorney for this office. That's the whole issue. That's the first issue. The second issue is that there was already an interim appointment by President Trump. That was Eric Siebert. He resigned, and Bondi appointed Halligan at President Trump's urging. Now, those two motions to dismiss are both compelling, in my opinion. They're both compelling. But the prosecution here is going to get a chance to file a response. And their response may also be just as compelling or more so. I'll be interested to see it. But what they can't get around, what they're going to have to respond to, and I just don't know how they're going to get around it, is the factual errors that are in that have become glaringly obvious in this case. As I said earlier, Comey's motion to dismiss for vindictive and selective prosecution contains within it a motion to dismiss based on the facts of the case, which is that the facts of this case don't agree with the indictment here. I need to, I'm going to make a change here. Let me go back and reopen these. As soon as I get these out of order, and I want to go back and start again. So now we're going to get more into details, and I hope all of you will stick with me. Sorry I didn't get that brief overview done in the first 30 minutes. It took me about 40 minutes, but now we're going to get to what I think is actually the most important piece of this, which is the glaringly obvious flaw in the indictment. And for that, we're going to have to get into some details. So, refill your coffee cup. I'm going to refill mine. We're going to go into the motion to dismiss for vindictive and selective prosecution. But we're not going into it to examine that actual argument. We're going into it to examine the flaws that are in the indictment, the dissonance between the indictment and the evidence that they have, the dissonance between the facts and this indictment. And this is where I think this case is going to fall apart. Okay. Before we dig into the details, just want to remind everybody about my link tree. I want to remind you that I got my YouTube back recently, and I would really appreciate folks going over there and subscribing to me on YouTube. And I would love to hear your comments and your thoughts. And if you haven't liked this video, wherever you're listening or watching or whatever it is, whatever way you prefer, I appreciate you listening and watching my shows. And I would like to hear back from you. I read all of the comments that come in. I don't always respond to them, but I do read them. And I appreciate them, even when you disagree with me. I like hearing it, because the point here, the reason I do this show is not to find people who agree with me. The reason I do this and my motivation is curiosity and admiration for justice and the pursuit of it. And just how much I enjoy this discovery process of going through and learning about these things that happened, and whether it's this criminal case or some other one. I get great satisfaction from learning this info. And when I read the comments and I see folks respond in a way that lets me know they're also enjoying this process of learning these things and thinking about these things, that is very gratifying to me and encourages me and inspires me to do more of this. Something that is a bit different about the show that we do here is that I enjoy the process of thinking about it over and over again. And I like other people who enjoy continuously thinking about this information and looking for ways to see it from different angles. So it doesn't, going into this case, if we went into it and we found that, man, the DOJ's allegations against Comey here, how is he going to get out of it? Like, if that's what we actually find out, if DOJ comes back and responds to these motions to dismiss, and if this case proceeds and we are enlightened as to other things, especially, that would be amazing, things we didn't know about. But if also they make it absolutely, completely, plainly clear that Comey committed an offense, a crime, and that he is guilty of it, and they have the evidence to back that up, then by all means, hold him accountable. I want Comey, if Comey committed a crime here, as alleged in the indictment, I'm going to go ahead and get the indictment because we're going to need it here in a minute. We're going to need to reference it here in a minute. If Comey committed the offense that it's alleged in this indictment, And he lied to Congress when he said that he had not authorized someone else at the FBI to be an anonymous source in news reports, when in fact he had authorized person 3 to serve as an anonymous source in news reports. And then therefore that was not just a lie to Congress, that was an obstruction of the congressional proceeding and the investigation that they were doing. Hold him accountable. And I feel the same way about McCabe. I feel the same way about Strzok. I feel the same way about Emil Bovee. If that happened with him, I feel the same way about Todd Blanche. I feel the same way about A.G. Bondi or Cash or Devin Nunes or anybody else. If the person, whoever they are, committed an offense, a chargeable offense, and there's the evidence to prove it, and the prosecution can convince a jury or a judge of it, and the defense puts up their best defense against it, and when it all shakes out and we learn, or like a conclusion is reached in a proper court setting, hold them accountable. But I also just as much want to see when people are falsely charged or when the defense is not convincing or the evidence isn't there. I want to see them not guilty or the case dismissed. And so, and I enjoy other folks that leave comments on my shows and quote them and share them, who also enjoy this process of discovering these things and learning about the process and learning about the cases and the subjects at issue here. And one thing that makes this extra interesting is we know who person 3 is. We've known who person 3 is since the indictment came out. We've talked about it over and over. We've entertained other possibilities. And that's another thing that I like about this audience is you guys rode with me as we went through the possibilities. And you've heard me in the past month talk about the potential of person 3 being Daniel Richman, James Baker, James Rubicki, or Andy McCabe, or some other person. And we've entertained those and chewed on them and wondered what if. And I enjoy that. But now we know who it is. It's Andy McCabe, which is who we early on believed it to be, which is why I did an entire episode devoted to that. And now we know that that is true. And that's a fatal flaw in the case. And that's what we're going to get to right here. Now, I'm not going to read the entire. Also, thank you to everybody who's listening, who's staying with me for the more detailed section of the show. And I promise I'll go back through some of these other memos or other filings in the docket and get you all the details that I find super interesting and then that I skipped over earlier. Okay. I'm going to skip over the stuff we basically already covered about the vindictive and selective prosecution. I want to go to the facts that are at issue here. All right. So starting here, it's going through the facts and Comey's service and FBI and director since July 2013. He was Senate confirmed. And then Comey oversaw daily operations of the FBI, et cetera, et cetera. Among the investigations, Mr. Comey supervised Crossfire Hurricane, a counterintelligence investigation into alleged links between Trump's campaign, not Trump, Trump's campaign and the Russian government, which there were, as well as the mid-year exam, which was the 2016 investigation into candidate Hillary's alleged mishandling of classified information during her tenure as Secretary of State. After President Trump was elected in 2016, Mr. Comey continued to serve as FBI director. On May 3rd, 2017, Comey testified at a Senate Judiciary Committee's annual FBI oversight hearing. Many of the questions focused on Mr. Comey's handling of Crossfire Hurricane and the mid-year exam. Investigations related to President Trump and Secretary Clinton, respectively. As relevant here, Senator Chuck Grassley asked Mr. Comey, quote, Have you ever authorized someone else at the FBI to serve as an anonymous source in news reports about the Trump investigation or the Clinton investigation? Comey answered no. And they have an excerpt here that's going to be Exhibit B. And I believe this is the one that I really liked the highlights they did. I'm going to go ahead and open up all these attachments. Yeah, there's the appointment of Halligan, attachment A. Attachment B is a transcript from the Senate Judiciary Committee on May 3rd, 2017. And if you scroll, bam. And I love it that they highlighted that for us. I bet the judge loves that too. Oh. I'll move that there and move this back over here. Okay. On May 9th, 2017, President Trump fired Comey as FBI director. That's 7 days later. Now, side note, which is a side note, but it's related because it has to do with the memos. Comey wrote memos after a meeting with President Trump. And he did them for his own preservation, to record interactions he had one-on-one with President Trump during this time because he believed they could be relevant later. And they are. And he believed they should be memorialized. And he saved these and he sent them to his attorneys later on. They were unclassified. Some of them were later up-classified after Comey was fired and McCabe was in charge. Why do you think McCabe did that? Why do you think McCabe had them up-classified? Because he was trying to go after Comey and stab his former boss in the back. Anyway, one of the memos that he recorded had to do with telling the president that he, Trump, was not under investigation by the FBI. And President Trump wanted Comey to say that to the press because the press were saying that President Trump was under investigation by the FBI. But Comey had already told President Trump that he was not under investigation. However, it is the FBI's policy for decades and decades not to tell the press whether or not someone is under investigation. It's kept secret. It's or confidential, I should say. Who and who is not under investigation is confidential. Who the subjects of an investigation are is confidential. Always. And it should be. But President Trump was taking a beating, quote unquote, in the media and wanted the FBI director to say aloud that he, Trump, was not under investigation, which is what Comey had told President Trump in private. In fact, I should get that and show you. Okay, here is the first memo. It is from January 7th, 2017, is the date it was sent. It's an email. And it says right here, what follows are notes I typed in the vehicle immediately upon exiting Trump Tower on January 6, 2017. Although I wrote this less than 5 minutes after the meeting and have tried to use actual words spoken, including quoting directly in some places, I have not used quotation marks throughout because my purpose was to capture the substance of what was said. I am not sure of the proper classification here, so have chosen secret. By the way, he did not share this memo. Please, or actually, let me look and make sure who he shared it with. I think he did not share it because it's memo 1. What I mean is he didn't share it with media or unauthorized people. He shared it with his chief of staff, Ribicki, and he shared it with McCabe, and he shared it with James Baker, and he shared it on a secure system. Let me make sure he didn't share it with anyone else. Let me see. I don't believe he did. Nope, he didn't. Okay. Let me go back to the memo. It's probably, if you guys have ever looked at this stuff, it's probably been a long time. All right. The notes begin here. During my brief, and by the way, he said, let me know if it should be higher or higher or lower than that classification of whatever, because, and then he's sending it to Deputy McCabe, he's sending it to Ribicki, he's sending it to Baker to get their feedback. Do you guys think I need to make this top secret? Do I need to lower it to confidential? I'm being cautious here, but I'm preserving my interactions with the president. And you can see some of it is redacted here. So we don't know what other things in here he might have said that were higher classification. So it talks about they had this exchange and they talked about blah, 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 going back and forth, introductions. And then down here, they get to the Russia investigation and Crossfire Hurricane that's going on. And he said, I said media like CNN had them and we're looking for a news hook, talking about reports. I said it was important that we not give them the excuse to write that the FBI has material or redacted, and that we were keeping it very close hold. He said he couldn't believe they hadn't gone with it. I said it was inflammatory stuff, that they would get killed for reporting straight up from the source reports, talking about Russia links and the story about prostitutes and the Ritz-Carlton and all of that stuff, right? Those allegations that were bothering Trump and bothering Melania. He then started talking about all the women who had falsely accused him of grabbing or touching them, with particular mention of a stripper who he said he grabbed her, who said he grabbed her, and gave me the sense that he was defending himself to me. I responded that we were not investigating him, and the stuff might be totally made up, but it was being said out of Russia, and our job was to protect the president from efforts to coerce him. I said we try to understand what the Russians are doing and what they might do. I added that I also wanted him to know this in case it came out in the media. This is when Comey alerts Trump to these allegations that may surface in the media. He said he was grateful for the conversation and said more nice things about me and how he looks forward to working with me, and we departed the room. So this is Comey alerting Trump to these rumors that are out there. The FBI is investigating that stuff, but not investigating him. And he is informing Trump of this stuff to protect him, to alert him to this stuff that might come out in the media. This is the Steele dossier, guys. These are the bullshit allegations that were in the Steele dossier. They were coming from Peskov, Dmitry Peskov, Putin's still press secretary, and Danchenko and Christopher Steele and all that stuff. If Comey was, well, anyway, if Comey wanted to hurt Trump, why is he alerting him to this stuff? All right. I believe later on, there's another part where he tells them that we're not investigating you. Okay. In this memo about discussing again about whether or not Comey wants to continue in the job and talking about how the government leaks and like all these different things that they talked about. They come back around to the fake news and Comey tells them that CNN in particular had told the FBI they were about to run the story about the golden showers and all that junk. And right here, let's see, right, they're building the USC already said around the morning. Where'd it go? Right. Trump said he thought he maybe should ask me to investigate the whole thing to prove it was a lie. I did not ask any questions, said Comey. I replied that it was up to him, but I wouldn't want to create a narrative that we were investigating him, because we are not, and I worried such a thing would be misconstrued. I also said that it is very difficult to disprove a lie. He said, maybe you're right, but several times asked me to think about it and said he would also think about it. And then they talked about his job and talked about how running the FBI. And they talked about Mattis and Sessions. He said he wanted honest loyalty, and I replied, you will get that from me. He asked again about McCabe and whether he was going to be okay. Comey affirmed Andy's ability and professionalism and said the president would come to see and benefit from both, which didn't really turn out to work very well. But of course, Comey's sending these around. He's not going to throw Andy under the bus. You know, he already has an investigation going at this point with the INSD, who's looking into the leaks that McCabe was ultimately responsible for to the Wall Street Journal, that now Comey has been charged with lying about, which doesn't make any sense, and we'll get to in a minute. Then they talk about Mike Flynn. Next memo. I want to see if, I think there's another one where he talks about the investigation. Talk about sourcings for some things, probably by their intelligence. Then the golden showers come up again. And Comey repeated what I told him, the president, about not wanting to create a narrative that we were investigating him. He then asked about leaks and the fact of redacted, and that it was briefed to the incoming president. And I said I didn't know where it came from, but I suspect it came from folks who left the government. And this is talking about the narrative that's getting created out there. He asked if we ever had caught an FBI leaker. I said we had, but it was a rare thing because it almost turned on our willingness to go after reporter records, which, by the way, they later did, and I put that in an article. He then recalled the Obama administration conflict with James Rosen on Fox, and he also mentioned the leak of the readouts of the president's call with foreign leaders. They talked about how bad that was. They talked about the FISA. He asked, do you have a FISA order on Mike Flynn? I paused for a few seconds, then said that I would answer here, but that this illustrated the kind of question that had to be asked and answered through established channels. I answered redacted, and then explained that the normal channel was from DOJ leadership to White House counsel about such things, redacted. I would normally make sure the AG and DAG were aware, and they would likely inform the White House counsel, and he could then decide whether to inform the chief of staff. I explained it was important that communications about any case in particular go through the channel to protect both of us, to protect the White House from any accusations of improper influence, which, very understandable. And then they talked about Reince Priebus, and then talked about his term and whether or not he would serve it out. Comey said he would remain if the president wanted him to. They're in conversation with Reince and offering his view that the Clinton team had misplayed the final announcement. They talked about Bernie. And they talked about Andy McCabe and how McCabe took $1 million from the Clintons. And then the readouts of the calls that leaked. And then the golden showers thing again. And then he pivoted to the Russians wanting an apology from Bill O'Reilly. It's a typical conversation with Trump. I think there's another one where he talks about not wanting to say that this is about Flynn, Sean Spicer. Again, they're talking about leaks and how bad they are and how they agree they need to go after whoever is leaking out of the FBI. Comey explained that he was a fan of pursuing leaks aggressively, but that going after reporters was tricky for legal reasons and because DOJ tends to approach it conservatively. He replied by telling me to talk to Sessions and see what we can do about being more aggressive. I told him I would speak to the Attorney General. At this point, Reince Priebus came in. Then they returned to the topic of Flynn. And both Comey and Trump agreed that Flynn is a good guy, but he's got to let him go because he misled Vice President Pence. Even though Flynn didn't do anything wrong in the phone call, he misled Vice President Pence, and that can't happen. So he's got to let Flynn go. The president then wrapped up the conversation. He walked out. As he walked out, Vice President Pence was standing outside the door. They shook hands, and then Tom Price was there, etc. I think this is the last memo here. This is March 30th, 2017. Now Christopher Steele's name is out there, talking about Miss Universe and the allegations again. And right here, Trump then asked what he could do to lift the cloud. And I explained that we were running it down as quickly as possible and that there would be great benefit if we didn't find anything, to our good housekeeping seal of approval, but we had to do our work, meaning running down the leaks, running down people in the FBI, running down everything had to do with Crossfire Hurricane. He agreed, but then returned to the problems this was causing him and went on at great length about how bad he was for Russia because of his commitment to more oil and more nukes because ours are 40 years old. He said something about the hearing last week, and I responded by telling him I wasn't there as a volunteer, and he asked who was driving that. Was it Nunes who wanted it? I said all the leadership wanted to know what was going on and mentioned that Grassley had even held up the DAG nominee to demand information. I said we had briefed the leadership on exactly what we were doing and who we were investigating, which wasn't Trump. I reminded him that I had told him we weren't investigating him and that I had told the congressional leadership the same thing in the classified setting, right? He said it would be great if that could get out, and several times asked me to find a way to get that out. It's right here. I can't highlight it on because this is an image. He talked about the guy he read about in the Washington Post. He meant Sergey Millian and said he didn't know him at all. He said that if there was some satellite, note I took this to mean some associate of his campaign, that did something, it would be good to find out, but that he hadn't done anything and hoped I wouldn't find a way to get out that we weren't investigating him. As the conversation ended, he said that he hadn't brought up the McCabe thing because I had said he was an honorable guy. Note, I think he meant that he hadn't brought it up in this conversation, but he could have meant something else. I repeated that he was. He then said he hadn't brought it up, but that McAuliffe is close to the Clintons and had given him money, but I said he was an honorable guy. I repeated that he, Andy, was an honorable person. He finished by stressing that he was trying to make deals for the country. The cloud was hurting him, meaning the cloud of the Russia investigation. He mentioned going to the G7 and having it hang over him, and he hoped I could find a way to get it out that he wasn't being investigated. I told him I would see what we could do, that we would do the work well as quickly as we could. At 10:05, I called the acting attorney general and relayed the substance of the above and said I was telling him so he could decide what guidance to give me. And then here's the final note right here. So, and I don't believe this one says anything about Trump not being investigated. Jeff Sessions recused himself. And yeah, he said he was calling me. President Trump called him at 8:26 a.m. on April 11th, 2017. And he said he was following up to see if I did what he had asked last time, meaning getting out that he personally is not under investigation. I replied that I had passed the request to the acting AG and had not heard back from him. He spoke for a bit about why it is so important. He is trying to do the work for the country, visit foreign leaders, and any cloud, even a little cloud, gets in the way of that. I keep bringing up Russia thing as an excuse for losing the election. I explained that Dana Boente was now the acting AG on this after Jeff Sessions recused himself. He said maybe he would have his people reach out to Dana. I said that that was the way to handle it. He should have the White House counsel call the acting attorney general and make the request. He said that that was what he would do. He then added, because I've been very loyal to you, very loyal, we had that thing, you know. I did not reply or ask him what he meant by that thing. Instead, I said again that the way to handle it was to have the White House counsel call Dana, and he said that's what he would do. And then they switched topics. Comey adds in a footnote, I assume when he said this, that he was reaching back into memory of our conversation about loyalty at the private dinner, which was sufficiently awkward to make it difficult for him to say I had promised to be loyal, which is where I thought he was headed in the comment. Okay, so I wanted to get into all that. Sorry for that rabbit trail, but I think it's important. Well, actually, I know it's important. because Trump was not under investigation. So how could a leak manifest that was trying to characterize there as being some investigation of Trump? It would be done corruptly. So right here, in this question from Chuck Grassley, sorry for that long rabbit trail. Back to the motion to dismiss for selective and vindictive prosecution. Stuttering over words. Chuck Grassley asked Comey, this is May 3rd, 2017. Quote, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation, which Trump was not under investigation? This would be the investigation into the Trump campaign, or the Clinton investigation, which either means mid-year exam email investigation or the Clinton Foundation investigation. Mr. Comey answered no. On May 9th, 2017, President Trump fired Comey as director. Thereafter, various prosecutors at the DOJ and FBI investigated whether Mr. Comey had committed wrongdoing during his tenure at FBI as director. And all investigations concluded with no charges against him. That's Durham and Arctic Hayes, and it's Horowitz. In August 2017, and it's John Durham. In August 2017, the DOJ and the FBI initiated Arctic Hayes, an investigation into whether Mr. Comey had illegally disclosed classified information to the news media through Daniel Richman, a Columbia Law School professor and former FBI special government employee. See memorandum on closing Arctic Hayes investigation, which was declassified this summer. And we've gone over those. The government ultimately concluded that there was not sufficient evidence to criminally charge any person, including Comey or Richman. Additionally, in March 2019, Attorney General William Barr appointed John Durham as special counsel to review the FBI and DOJ's handling of investigations into alleged connections between President Trump's campaign and the Russian government. And then there's the Durham report, which we've also covered in great detail many times. As part of the investigation, special losing the ability to speak, Special Counsel Durham scrutinized whether the FBI had mishandled the Crossfire Hurricane investigation. Although the final Durham report offered critiques of the FBI's handling of the FBI's investigative standards, it did not find that Mr. Comey or any other senior FBI personnel violated any federal criminal statutes. As a private citizen, Mr. Comey criticized President Trump. Mr. Comey has vigorously and prominently exercised his First Amendment right to criticize President Trump and vice versa. In response, President Trump has repeatedly attacked and threatened Comey. That pattern began soon after Mr. Comey's May 2017 termination as FBI director and has continued up until and even after the indictment in this case, which I think is kayfabe because they're aggressively going after the leakers, as we just read in the memos. Setting that aside for now. It's going to go on to list all of the comments they've made in between to each other, okay? We're going to skip those. We're going to skip all that. It matters, but you guys know it. Everybody knows it. Everybody knows what Trump has said about Comey, and everybody knows what Comey has said about Trump. And it just is what it is. It's their First Amendment right to do that, but when one of them has the power to indict the other and does so, there's a strong appearance of selective and vindictive prosecution, isn't there? And that's the point of all of this. Also, Trump abruptly, or DOJ abruptly fired Mr. Comey's daughter, Maureen Comey, a veteran U.S. attorney in the Southern District of New York, which I think was a horrible thing to do and was probably politically motivated. And Ms. Comey is suing DOJ over her firing. And I think she's going to win. I think she's going to prevail, or at least should. all of her performance reviews, including one earlier this year, was outstanding. Says so right there. And it's very difficult to see any other answer as to why Miss Comey was fired other than political motivation, which is wrong. Just flat out. It'd be wrong if Biden did it, and it's wrong if Garland did it, and it's wrong if Bondi and Trump do it. Okay, and then we're going to go through all that. And then it brings up Kash Patel and his allegation on Joe Rogan's podcast that they found a room that Comey and others hid from the world at the FBI that had burn bags. And although it is unclear whether and to what extent the government coordinated or jointly conducted the two investigations, a similar pattern of pressure and resistance appears to have played out in the Western District of Virginia, where the interim attorney there was forced out because he wouldn't indict some people, supposedly, for document crimes related to those burn bags in this hidden room, which is in Winchester, Virginia. And we went over that. It's Todd, not Todd Blakely, Todd Gilbert, who is also the same Todd Gilbert that the Democrat for AG who's running in this state, Jay Jones, said he wished would die, and he wished that his family would be killed so they would learn a lesson or something. Same Todd Gilbert, by the way. One of my commenters asked me if they were the same. We went over that on this episode 346. We went over those investigations. Okay. Okay. And then it goes over the firing of Siebert or the resignation of Siebert. We went over this section here. I want to get to the facts of the case. I'm going to show you the flaw in this case. Yep. Here we go. Here we go. Ooh, I see something I gotta do. Okay. Count 1 of the indictment charges Mr. Comey with making false statements to Congress in alleged violation of 18 U.S.C. 1001. The indictment alleges that on September 30th, 2020, Mr. Comey falsely stated to a U.S. senator during a Senate Judiciary Committee hearing that he had not authorized someone else at the FBI to be an anonymous source in news reports regarding an FBI investigation concerning Person 1. We know Person 1 is Hillary Clinton, and that has been confirmed by DOJ right there in the footnote. They confirmed to defense Person 1 refers to Hillary Clinton. Person 3 refers to Daniel Richman. This is a very, very important. The indictment further alleges that Mr. Comey's statement was false because, as Mr. Comey then and there knew, he in fact had authorized Person 3 to serve as an anonymous source in news reports regarding an FBI investigation concerning Person 1. Again, Person 1 is Hillary. Person 3 is Richmond. Count 2 charges Mr. Comey with corruptly endeavoring to influence, obstruct, and impede a Senate Judiciary Committee investigation on or about the same date by making false and misleading statements before that committee. That's a violation of 18 U.S.C. 1505. On September 25th, Trump celebrated Mr. Comey's indictment on social media, said all these bad things about him, and thanked Kash Patel, and again reiterated that James Dirty Cop Comey is a no good, very bad person, total slime ball. Again, thank you FBI, and thank you Lindsay Halligan, and thank you DOJ, and all that. There's nothing wrong with all that. It's fine. It's fine. Here's what's wrong. The indictment is facially flawed. It focuses on testimony that Mr. Comey gave in response to questioning by Senator Ted Cruz at a Senate Judiciary Committee hearing on the Crossfire Hurricane investigation, which was about examining links between Russia and the Trump campaign, not about the mid-year exam, not about the Clinton Foundation investigation. It was about Trump campaign Russia collusion, alleged links there based on the Steele dossier and other garbage, right? That's what the hearing was about. During that hearing, Senator Cruz described how, during 2017 testimony before the Senate Judiciary Committee, Mr. Comey had denied, quote, ever authorizing someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration. Excerpt of transcript linked there, right here. And it's also Exhibit C, which we can go to right here, Exhibit C. Right there. Graham introduces everything. Thanks, Mr. Comey, for being there. Thank you here to talk to us about Crossfire Hurricane and anything else the committee wants to speak to you about. Talk about FISA, Crossfire Hurricane, Crossfire Razor investigations, Carter Page warrant application. There's Feinstein and her quotes about what they're there to talk about. And here's Cruz. Starts off asking some questions about these. Talks about Inspector General Horowitz, Inspector General report, which found 17 significant errors or omissions in the Carter Page FISA application. Talks about CIA and Kleinsmith, Steele dossier, being funded by the DNC and the Hillary Clinton campaign. And then more talk about FISA. And then political bias, Democrat opposition research, that the primary subsource for the Steele dossier was a suspected Russian asset. And then talks about recruiting spies against the U.S. government, and you have a Russian agent that is the basis for an FBI investigation. And then Cruz. All right, let's shift to another topic. On May 3rd, 2017, in this committee, you were asked by Grassley point blank, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? You responded under oath, never. He then asked you, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration? You responded again under oath, no. Now, as you know, said Cruz, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth? Comey stated, I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017. Cruz responded, so your testimony that you've never authorized anyone to speak or anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct? Comey, again, I'm not going to characterize any testimony, but mine is the same today. Cruz says, all right, I'm going to make a final point because my time has expired. And then he goes on. Talk about weaponized DOJ. So they restate that here. The indictment in this case, right here, this 2-count indictment against James Comey misstates the exchange between Senator Cruz and Mr. Comey. Senator Cruz asked Mr. Comey to affirm or deny prior testimony that he authorized, quote, someone else at the FBI to be an anonymous source in news reports about the Clinton administration. But Hillary Clinton was not elected, and Senator Grassley's original questioning in 2017 related to the Clinton investigation. And that transcript is also here, right there. The indictment nonetheless mischaracterizes Mr. Comey as stating that he, quote, had not authorized someone else at the FBI to be an anonymous source in news reports regarding an FBI investigation concerning person one, who is Hillary Clinton. Thus, the indictment replaces Senator Cruz's reference to the Clinton administration with a reference to person one, Hillary Clinton, and misleadingly attributes statements to Mr. Comey that he did not in fact make during his September 30th, 2020 testimony. Footnote: Mr. Comey expects to move to dismiss count one based on a defense of literal truth. And this is what I was talking about earlier in the show. There's a motion to dismiss for this indictment being factually flawed on its face within this motion to dismiss for vindictive and selective prosecution. What is in this indictment here? The literal words and quotes in this indictment, which are the basis for charging Comey with lying to Congress and obstructing Congress, are not accurate representations of the transcripts they're based on. They're not talking about the same thing, and it misquotes the transcript. Further, the indictment omits Senator Cruz's words that explicitly narrow the focus of the questions, and this is even more important, I think, because maybe you could forgive it saying Clinton administration versus Clinton investigation. Maybe you could forgive that, okay? And you could say, like, look, we know what they're talking about. It's a typo, or we believe that it was a typo here, or that Cruz misspoke when he said administration, right? That what Senator Cruz really meant was the Clinton investigation, meaning the mid-year exam or the Clinton Foundation investigation. So it's just Cruz misspoke here. Okay, so you could surrender that, and I think that's understandable. Okay, but there's another flaw that I think is actually worse. The indictment omits Senator Cruz's words that explicitly narrow the focus of the questions to concern Mr. McCabe, and it misleadingly implies that the questions related to Mr. Richmond. In fact, Mr. Comey's September 2020 exchange with Senator Cruz made no reference whatsoever to Mr. Richmond, who ultimately appears in the indictment as person three. Instead, the context of the exchange confirms that Senator Cruz was asking about leaks by Mr. McCabe. Indeed, Senator Cruz asked Mr. Comey whether he or Mr. McCabe was telling the truth. In other words, the indictment presents an inaccurate description of the testimony at the heart of this case. Comey is indicted for lying based on this exchange. But the government has informed the defense that person one in this indictment is Hillary and person three is Daniel Richmond. Daniel Richmond never came up in this exchange. Daniel Richmond is not who Cruz is asking about, and it wasn't who Grassley was asking about. They were asking about McCabe, which is why after Comey said no, Cruz then brought up McCabe's testimony and the conflict between what McCabe told the committee and what Comey is telling the committee. Scroll back down here. This is fatal. You can't be indicted based on quotes that aren't about what the indictment says they're about. Like, it's literally the wrong person. They're literally talking about something completely different. And there's all these news reports and comments on social media by influencers and big accounts and whatnot saying that the indictment is about Daniel Richman, which is what the prosecution says. And Comey leaked through Daniel Richman to the New York Times and all of these things, but that's not what was being talked about in the hearing on which the indictment is based. It's a complete fatal flaw. It appears that what has happened here, and I wrote it somewhere earlier, and I think the way I wrote it here, I want to quote for you guys because it just makes a lot of sense. Here, let me go to my replies, and I'll find it really quick in my replies. Because this I kind of summed up what this makes apparent. It's very much like Halligan has charged Comey for an alleged lie in an exchange with Cruz, but is using evidence from an entirely separate matter, and one where both Durham and other investigators, across like 4 years of looking into it, found no evidence with which to charge either Comey or Richman with a crime. Durham, United States Postal Inspection Service, the Washington Field Office, and this same Virginia U.S. Attorney's Office all looked at the allegations that Comey and Richman leaked to the media and found no evidence with which to bring a charge against either of them or anybody else. That was Arctic Haze and Tropic Vortex and those media leak investigations which we've looked at a number of times recently and that were memos from were declassified over the summer. And yet, Lindsay Halligan has come in and has charged Comey for lying about authorizing Daniel Richman to leak to media, saying that in fact he did authorize Richman to leak to media. But she's using quotes from an exchange in the Senate with Senator Cruz, who's quoting an exchange between Comey and Grassley months before, where they're not talking about leaks to the media, specifically the New York Times. They're talking about McCabe and the leaks that we know appeared because of McCabe. And what were those leaks about? Those leaks were from October 30th, 2016, and it was this article. It was to the Wall Street Journal, Devlin Barrett, FBI in internal feud over Hillary Clinton probe. The leaks that are in this article, we know for a fact, came from Andrew McCabe. And he leaked to Devlin Barrett of the Wall Street Journal via Lisa Page. And he lied about it over and over. See right here? Lack of candor. Lack of candor, lack of candor, lack of candor, lack of candor. McCabe lied to Comey and pretended in November of 2016 that he didn't know where the leaks came from. Comey directed the inspection division of the FBI to go and investigate where the leaks came from. McCabe lied to the inspection division over and over, and they referred the matter to the OIG. The OIG interviewed McCabe, and McCabe lied to Horowitz and his investigators. But then he found out that Horowitz had Lisa Page's text messages, and he knew he was caught. So then he came partially clean, but again he lied right here. Lack of candor in an interview under oath, November 29th, 2017. He lied again. It had to be shown, no, you're not telling us the whole truth. So That is the subject of the conversation. That is the leak at issue. When Cruz brings up, what about McCabe? McCabe says you authorized him to do this. And Comey says, I can only speak to my testimony. I stand by my testimony that you summarized from May of 2017. At that time that Comey said that, he knew there was an investigation ongoing. He's the one who ordered it to investigate where the leaks came from. And what was the leaks that he ordered investigated? This one. Because this had to do with Clinton's email server and the Clinton Foundation investigation, both of which Andy McCabe interfered in, corruptly interfered in. And yet, Lindsay Halligan has brought an indictment of Comey and has indicted him for authorizing Daniel Richman, who wasn't a source to the New York Times. He wasn't a source to the Wall Street Journal. He was a source to the New York Times, and he has already stated he wasn't authorized to be one, that Comey never directed him to serve as a source. He did it on his own. So we have this mishmash of these separate investigations and these separate matters and these separate leaks. It's all mishmashed together. And media is characterizing this as being about the Comey memos, and his lead counsel needs to be disqualified because Comey shared one of those memos with him, and now he's been indicted for leaking the memos. But that's not what this is about. This is about this. And we know that because person one in the indictment is Hillary Clinton, and because that is the subject matter of the questions that were being asked of Comey in May, and were being asked of Comey in this testimony, but in May between Grassley and Comey, and in this testimony in 2020 between Comey and Cruz. Now, maybe DOJ comes back and they've got a brilliant answer as to how this indictment is not flawed. Maybe they come back and they've got a really great answer here as to how it is that Comey was lying there. And, maybe they're going to say something like, I'm scrolling through here to see if there's anything else I wanted to bring up from the motion to dismiss for vindictive prosecution. I don't think there is. I really wanted to focus on the factual issues here between the indictment and the evidence that has been presented here. So maybe they come back and they say, look, our argument in the indictment, our argument that what we're going to prove in this case, what we aim to show a jury, is that this was a lie by James Comey because he had authorized Daniel Richman to serve as a source in news reports. And this is a lie because he was asked if he had authorized someone else at the FBI to be an anonymous source in news reports. So they are going to go back here. Grassley's going to say, hey, thanks for being here, blah, blah, blah. Comey, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? Never. He's not charged with lying when he said that. Okay, that's not the part. Question 2 from Grassley. On a relatively related, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation? Comey says no. Then Cruz here. But Comey's not indicted for this. He's not indicted for this. And it's past the statute of limitations anyway. Comey's indicted for this, where Cruz asked him, Cruz quotes Chairman Grassley, quote, "Have you ever been an anonymous source in news reports about matters relating to the Trump investigation or Clinton investigation?" You responded, "Never." He then asked you, "Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration?" And you responded again under oath, "No." Mr. McCabe says different. Mr. McCabe has publicly and repeatedly stated that he leaked to the Wall Street Journal, meaning this right here, and that you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth? Comey says he stands by his testimony. So your testimony is that you never authorized anyone to leak, and Mr. McCabe, if he says contrary, is not telling the truth. Is that correct? Comey says again, "I'm not going to characterize any testimony, but mine is the same today." They're saying that's a lie. But those questions were not about Daniel Richman. Those questions were about McCabe and this article, which we know McCabe was the source for. And we know that because right here. In this investigation right here. This investigation right here is all about McCabe being a source to Devlin Barrett, and Horowitz got the text messages, Horowitz got the emails, Horowitz got interviews with McCabe and Lisa Page, and Lisa Page told him everything. So how does this indictment stand? It may not. Okay. I had to step away, go get my kids from school. I'm back, and I've definitely, we've been going at this for a while. What I want to do is I want to back off of this and show you some of the odds and ends that are in the other motions that I skipped over earlier in the show. But before I do, I just want to reiterate that if or when prosecution comes back and counters, they give a reply in opposition to this motion to dismiss, I would expect that they're going to argue that because of this line, that Comey said he didn't authorize someone else at the FBI to be an anonymous source, they're going to say, in fact, he had authorized Daniel Richman, number 3. And so even though this doesn't match up with the testimony, that Daniel Richman being person 3 in this indictment doesn't match up well with the transcript of the exchanges between Comey and Grassley and Comey and Cruz, prosecution's going to argue that Comey did authorize someone else at the FBI, that he did authorize Richman. The problem, I think, with that theory, which must be their theory, is that Comey's understanding, as evidenced by the transcript itself, was that Cruz was asking about McCabe. The whole thing was in the context of McCabe, as was Grassley's original questions. It was all about McCabe, not Richman. Richman's not mentioned anywhere. So you can't, or at least it's a big, big ask to believe that Comey corruptly misled Congress, that he had a corrupt intent in his answer to Congress in those interactions, because the whole thing was about McCabe. And I love that Patrick Fitzgerald here used the line, "No reasonable prosecutor would have brought such a deficient case." I love that. Others may not find it as humorous as I do, but I find it very humorous. Okay. I also want to show you, if you might guys remember, we've been going over all these media leak investigations. We have this list here. I think it was Cody who put this together, this chart of all the different media leak investigations. And the one that's Arctic Haze is right here. And that has to do with the Dutch intelligence that had the Russian memoranda, which was the Clinton plan intelligence. And that stuff was leaked to the New York Times and Washington Post and Wall Street Journal. And, but somehow, I don't know how Harold Jenkins got it at Wall Street Journal, but this is what the Arctic Haze investigation was about, okay? And in that investigation, Arctic Haze, we have these declassified memos. And if you scroll down here, Richmond had meetings with the New York Times. And Richmond was quoted in the New York Times several times, both on the record and on background in stories regarding Comey. And this was after Comey was terminated by President Trump. Comey used Richmond as a conduit to convey to the media memoranda of his meetings with the President Trump. But guess what? This question in the indictment, and the question that, as it was asked here, have you ever been an anonymous source in news reports? No, never. Have you ever authorized someone else at the FBI to be an anonymous source? No. Well, Comey wasn't at the FBI when he used Richmond as a conduit to the media. And Richmond was quoted in the media. He wasn't an anonymous source. The investigation, Arctic Haze, revealed Richmond had been a source for Michael Schmidt, one of the reporters credited with writing the article at issue in the investigation. Richmond first spoke with Schmidt regarding an investigation into illegal activity in sports. Prior to Richmond becoming a special government employee, which he was for a time while Comey was at the FBI, Schmidt visited Richmond's house numerous times. The New York Times would quote Richmond several times on both record and on background in stories regarding Comey. After he was terminated by President Trump, Comey used Richmond as a conduit to convey to the media memoranda of his meetings with the president. And then this section's redacted. I'd really like to know what's here. Maybe we will. And I'd really like to know what comes after this. Although Richmond later told the interviewing agents Comey never asked him to talk to the media, redacted. So, whatever's under these redactions could completely alter or render much, much weaker what is in these motions to dismiss. And then if you go down here, it says November 22nd, 2019, the Arctic Haze investigative team interviewed Richmond. According to Richmond, Comey and Richmond talked about the hammering Comey was taking from the media concerning his handling of the mid-year exam investigation. Richmond opined Comey took comfort in the fact Richmond had talked to the press about his feelings regarding Comey's handling and decision-making of the mid-year exam investigation. Richmond claimed Comey never asked him to talk to the media. Then we have more redactions down here. So maybe we will find out what is under these redactions in the reply to Comey's motion to dismiss. But remember, this Arctic Haze investigation was looked at for years by investigators in the Washington field office and Durham and U.S. Postal Inspection Service, I believe. I don't think I'm getting it mixed up. Washington field office looked at it. No, Durham and USPIS was Tropic Haze. But he also looked at this because they ended up putting everything together for these multiple leak investigations. And they decided not to bring charges. Because, look right here. Due to the inability to further narrow the subject pool and lack of other logical investigative steps, Washington field office has exhausted all leads in furtherance of the caption investigation. Since there is no way to accurately scope the subject pool, additional techniques would not be effective in advancing the investigation, and insufficient evidence exists to pursue additional legal process. They closed it. Hopefully, we're about to, in the prosecution's reply, we're going to find out a lot more. Okay. I'm going to bounce back off that. We're done with the motions to dismiss. I want to show you this right here. Yeah. So when the DOJ urged Nachmanoff to quickly rule on the motion for a filter team, they said in that filing, the evidence for the filter review could contain exculpatory or inculpatory evidence. The evidence for filter review could also inform a potential conflict and disqualification issue for the current lead defense counsel, Patrick Fitzgerald. So they're indicating we might move to disqualify Comey's lead counsel because what we want the filter team to look at involves him. He's a party to some of the communications. But it says the stuff in there could help Comey or it could hurt him. When you go right here, further down in the motion, the attorney evidence comes from and has informed investigators that Patrick Fitzgerald is among the parties communicated with in the evidence. Evidence in the government's custody includes potentially protected material because the evidence was obtained from an attorney. Relevant to this motion, the attorney has informed the government that the quarantined evidence contains communications between the defendant and several attorneys. The current lead defense counsel appears to be a party to some of those communications, which this makes me think of the Comey memos, which Comey shared with Fitzgerald, Daniel Richman, and David Kelly. And which DOJ's Inspector General Horowitz has already looked at and found no crime. In fact, this memo or this motion quotes from the report on those memos, which found Comey did not commit a crime. Horowitz criticized Comey's decision-making and handling of the memos, said he should have gone about it differently, but there was no crime, there was no chargeable offense. Comey hired Richmond and Fitzgerald as personal attorneys and gave them memos he created during the first several months of 2017. Those are the ones we looked at earlier in the show, these right here. All of these that we looked at. Comey told the OIG, this is from the report, that the day after his removal, or very shortly after, he retained attorneys Fitzgerald, Kelly, and Richmond to provide advice and counsel in connection with Comey's termination as FBI director and any post-termination legal issues that might arise. Comey gave copies of memos 2, 4, 6, and 7 to Patrick Fitzgerald. Fitzgerald forwarded those memos to Kelly and Richmond. This is from the IG report, which I have right here. It has this nice little section that gives you the dates of what happened with each memo and when. Or to whom, I should say. Memo 2 would later be upclassified. Memo 2 contained 6 words that were classified confidential, no foreign intelligence, which Comey did not redact. Memo 4 and 6 were unclassified, but were for official use only. Memo 7 had a portion classified as confidential, no foreign, which Comey redacted before sending. DOJ wants the material reviewed by a filter team as soon as possible so that they can confirm the conflict of interest and move to disqualify Fitzgerald on that basis. Comey will likely assert privilege over this evidence. And then right here, I linked those filings. Comey responds to the prosecution's motion to hurry a decision on the filter team by saying, and he says in the filing, there is no good faith basis to claim a conflict between Mr. Comey and his counsel, much less a basis to move to disqualify the lead counsel. Defense hasn't responded to the motion for a filter team, but doesn't have to until October 27th, which I went over earlier in the judge's order on this. But curiously, check this out. What defense wants to do, the reason that they had what they told DOJ. Sorry, let me back up. Before prosecutors filed for the filter team, made this motion for a filter team, they talked with defense. And defense said they weren't opposed to the filter team, but they wanted to challenge the underlying warrant first. And then they filed a sealed exhibit. And in that sealed exhibit, I think, has what they're referencing in these redaction blocks. So this is Comey's response to the motion to expedite, okay? I know this is getting a little confusing. I'm really sorry. Well, we have this section here with these redactions. Let me go to the filing. Show you right here. So, order of things as concerns the filter team. Government met with the defense. Sorry, I keep saying government, DOJ, prosecution. I mean the same thing. The prosecution met with the defense, said they wanted to move for a filter team because they had this quarantined evidence that was potentially privileged. Defense said, we're not opposed to the filter team, but we want to challenge the underlying search warrant from which you gained this quarantined evidence that's potentially privileged. We want to challenge that search warrant first. And then we'll deal with the filter team, which is going to make things take longer. DOJ doesn't want to do that. DOJ wants the filter team now so that they can get this figured out and get all these privilege issues sorted. Okay? So DOJ files their motion for a filter team. Comey's team hasn't responded to it yet. They have 14 days. 7 days after filing for it, DOJ comes in, or prosecution does, and files a motion to expedite the judge's ruling, saying, Judge, please rule on this as soon as possible. Comey's team then has to respond. So in their response, which is right here, just 3 pages, they say, hey, look, we have, according to local rules, we have 2 weeks to respond to this. Actually, that's not what I wanted. It's this one. Yeah, this one, 8 pages. That makes more sense. Like, according to local rule 12, we got until October 27th to respond to this. And this is important because based on the defense's review to date, it appears the government's continued review of materials is unlawful. So we want to bring that up because we think they're already peeking at this stuff. Also, the government's effort to defame lead counsel, saying that there's some sort of conflict and he needs to be disqualified, there's no basis to grant the motion. The court should deny the government's motion for expedited decision. The defense is entitled to look at this stuff and respond before the judge rules, obviously. The defense needs 2 weeks provided by the local rules to respond. This is critically important to avoid trampling on Comey's legal privileges and to ensure the government does not proceed with an unlawful review. When the government first raised the privilege protocol with defense on October 10th and 11th, defense asked for an opportunity to review the underlying warrants at issue to determine whether Mr. Comey would agree to the protocol. The government refused to provide the warrants before filing its motion for a filter protocol or filter team. and did not produce those warrants until October 13th. The government acknowledged that the warrants were obtained, quote, in a previous investigation from an attorney. What the government does not say was that the warrants at issue were obtained by prosecutors, redacted. Footnote, we're redacting this stuff, Judge, because we're trying to comply with the protective order, and out of an abundance of caution, we're going to redact this section. Because some of these words deal with evidence that we acquired from the prosecution. They might fall under the protective order. This filing goes on to say, what is more, the warrant seized, redacted. Mr. Comey did not participate in the prior review of those materials. The government has to date refused to answer the defense's questions about the legal basis to continue to review materials pursuant to redacted that redacted. Similarly, the government has refused to answer questions about what precisely it intends to review from the prior warrants, particularly in the face of the government's refusal to answer basic questions about this proposed review, and in light of the serious privilege and constitutional concerns apparent from even a superficial review of the warrants. The defense needs time to diligently review the discovery to respond to this motion. Concerns about the potential review are amplified because the defense has reason to believe redacted, as set forth in the sealed exhibit. So the plot thickens when it comes to this. All right. Now let's go to what the judge said. There we go. I want that. And government, the DOJ filed a sealed motion here. No, wait, James Comey did. This is Comey's sealed filing here because he doesn't, what he put in this exhibit, they're saying it needs to be sealed for now, I think out of caution, but I'm not entirely sure. And then we have the order. Okay. So I'm going to refresh the document. Is there anything new while I've been talking today? No. Okay. So here's the judge's order where and it's the most recent thing in the docket, where he denies the government's motion for an expedited ruling for the reasons that are obvious. Comey has, by local rules, he has until October 27th to respond, okay? But if you go through this, he reveals some of what is in this right here. This is 54, right? Here, hold on. It doesn't have the dates. It doesn't have the stamp on it. Make sure. This is 61. 54. That's the motion to expedite ruling by USA. And then in the judge's order, all right, defendant filed an opposition because they want to review the relevant warrants and materials at issue in the discovery and respond to the government's motion for a filter team, particularly in light of the substantive motion schedule. Defendant claimed that this allotted time is critically important to avoid trampling on his own legal privileges and to ensure the government doesn't proceed with an unlawful review. Specifically, the defendant argues that the government has refused to specify what it tends to review. He also states that the underlying warrants were, quote, obtained by prosecutors. Okay, and I'm going to show you this. See this? Obtained by prosecutors and then redacted. We're going to see right now in the judge's order what's under the redacted part. Obtained by prosecutors in a different district more than 5 years ago in an investigation that closed without criminal charges and to authorize the seizure of evidence related to separate offenses that are not charged here. And that there is reason to believe that the two principal FBI investigators may already have been tainted by exposure to privileged information, which means they saw things they shouldn't have saw. They've been looking where they shouldn't have been looking. And we know this because of whatever they put in this sealed thing right here, whatever's in this exhibit, which we don't have access to. I know it says buy for 10 cents, but it won't let you. Defendant claims that all this requires diligent consideration by defense and comes, quote, as the defense is devoting significant time to the motions that were due today and October 30th. Further asserts the government's claim that he used lead defense counsel to improperly disclose classified information, the government's implicit assertion that the two engaged in criminal activity is provably false, based on public information, and provides no basis to support the government's motion to expedite or any conflict or disqualification. And they're right that it's provably false. It was already proven false right here, years ago, in this report by I.G. Horowitz that came out in August 2019. And that has to do with the Comey memos that we looked at. So, let me tell you why I think all this stuff is so interesting. A while ago, we went over some of the problems, the factual flaws, the apparent factual flaws, I'll say, with the indictment. And I'm going to tell you guys right now what I think is what's up. What is up with bringing a case like this against Comey? Why did they bring a case like this against Comey? I think it's this right here, because it's not about getting Comey. It's about getting something else. And I think that something else is behind attorney-client privilege, perhaps in the quarantined evidence that DOJ is seeking a filter team for. Defense doesn't or hasn't objected to the filter team, but wants to challenge the underlying search warrant first. And we see right here that what they're saying, what defense is put under those redaction blocks that the judge just revealed, the underlying warrants were obtained by prosecutors in a different district more than 5 years ago in an investigation that closed without criminal charges and authorized the seizure of evidence related to separate offenses that are not charged here. That's what I think is up. That is my working theory. I think they brought an indictment against Comey that is intentionally flawed because it's meant to fail as far as getting Comey. But it's meant to succeed on getting what this filter team is going to look at. Where's that filter team motion? Right, 13th. There it is. We go to this filter team motion. Yeah. Let's see. There was something in here. Maybe it was in the expedite. Maybe it was in the expedite motion. And hey, maybe the reason why they filed to expedite, even though they knew Comey hadn't had 14 days yet and it wasn't actually due, his response wasn't due yet. And of course, he has to respond before the judge can rule on a motion from either side. Both sides get to say before the judge is going to rule, right? That's how it works. In the motion to expedite, the evidence for the filter team review could contain exculpatory or inculpatory evidence. Evidence in the government's custody includes potentially protected material because the evidence was obtained from an attorney. Relevant to this motion, the attorney has informed the government that the quarantined evidence contains communications between the defendant and several attorneys. The current lead defense counsel appears to be a party. I think they are after material gathered that is attorney-client privileged that connects back to these memos and connects back to right. This one. I think it goes back to Tropic Vortex because they talked to Durham. We know the investigators talked to Durham. And this Tropic Vortex had to do with Alpha Bank and Trump saying in the media or telling the media that Obama tapped Trump Tower, that Obama spied on him. I think it has to go here. And I think it has to do with what Durham was looking at there that had to do with James Baker and let me grab. Okay, where is Tropic Vortex in this article? Don't remember if it did. Vortex. Tropic Vortex has to do with this article right here. And did I save those files under? Here we go. The Tropic Vortex, Durham ended up looking and like all these leak investigations got connected. And Tropic Vortex also connected back to Siren's Lure. Okay, because all of these media leak investigations informed one another because they were looking for a leaker, one or more leakers within DOJ and FBI, specifically FBI, I think. And in this memo here, in what Durham is looking at here, they declined to prosecute anybody. They didn't have enough evidence or any evidence to prosecute Comey or Richmond. I'm not sure exactly how he phrases it. But the declination information was put in the USA Durham memo in the US DC prosecutorial declination decision. And where is it? I want to show you where it talks about James Rybicki, Comey's chief of staff, and James Baker. Remember, I talked in a couple episodes ago, I was talking about the possibility that either Rybicki or Baker was person 3. And it's within this why I considered that as a possibility. Because on March 5th, 2017, the New York Times published an article titled Comey asked Justice Department to reject Trump's wiretapping claim. This article right here. And there was what was in there, what this investigation found is that Rybicki, Comey's chief of staff, forwarded an email containing a proposed statement to the news media regarding tweets, Trump's tweets. Rybicki forwarded this statement. There was a proposed statement. It wasn't finalized. It wasn't official. A proposed statement to his own personal email account. The proposed statement originated from Comey and appeared to be at the unclassified level of classification. The Washington field office assessed Rybicki did so in furtherance of a potentially unauthorized disclosure to the news media, which appeared to be at the implied something of Comey. Implied, it might be implied authorization, implied request, implied consent. I don't know. It's blocked out. Washington field office documented these findings and the assessment in redacted and presented them to the attorneys and agents and professional investigators that were assigned to Tropic Vortex, Echoes Fate, Foggy Falls, Genetic Christmas, and Science Lure. The whole thing. Except for Arctic case. And based on these findings and assessment, they decided not to keep going. They decided not to continue the investigation because there wasn't enough there. So what I'm wondering is this about getting Comey's proposed statement? Is this about getting Baker's communications with Rybicki? How did Rybicki get this impression? They interviewed Baker, and Baker said or indicated that the FBI chief of staff, Rybicki, instructed him, James Baker, to disclose the information to the New York Times, and Baker understood Rybicki was conveying this instruction and authorization from Comey. But the additional details are classified. So that's where my mind is going, guys. The indictment is flawed because it's not meant to get Comey. It's meant to get this 1A package, this Durham memo, and whatever is under these blocks of redactions from Arctic Haze. That's my working theory. Okay. I think that is it for this episode. Yeah. I think that's it. Thank you all for listening. If you enjoyed it, visit my Linktree. Make sure you're following me all these places. Please, wherever you're watching or listening, thank you. Please like, subscribe, comment. It really helps me out. Wherever you're watching or listening, it helps me out, but especially on YouTube, it helps me. And if you really like this content and you want me to do more of it, all of my support links are here. I really appreciate it. And let me know what you think about me trying to do a brief overview of everything in the beginning of the show and then saving a more granular review for the last half or so. I think I ended up doing what was supposed to be a 30-minute overview at the beginning. I think it ended up being more like 45 minutes or so. I'll work on that, but we did have a lot of material to go over. Yeah. So thank you. And hey, I think if there's ever a moment for me to say I'm just human, this is one of those moments where I can say I'm just human. I'm going through these documents and I'm giving the Comey indictment my honest and most fair reading, both from the prosecution side and the defendant's side. And when the prosecution replies, I'm going to try and be just as fair to what they put forth in their filings, okay? Just like I was, if you guys remember, in the Jack Smith cases against Trump, I tried to give Jack Smith's indictments and filings as fair of a read as I could. And really consider, okay, did Trump do something wrong here? Did he do something criminal? Or was it not the best course of action? I tried to be as fair as I could with each filing, and that's what I want to continue to do. That's what I would want done for me if I was indicted, right? And that's what you guys would want done for you if you were indicted, right? So I think that's the right way to approach these things. And it's what also enables us to whatever conclusion it reaches, it'll enable us to have just a more clear-minded understanding of the case and the who, what, why, when, and where of the whole thing. And if you remember an episode many months ago, I talked about how we don't want to be contrarians, and we don't want to be like team oriented political identitarians. We want to be clear thinking contrarians. We want to be human, just human. We want to be clear thinking contrarians. And that's how I'm trying to approach this. And I hope you guys are with me on that. Let me know your thoughts in the comments. Y'all have a blessed day, and I'll see you on the next one.